Good morning, everyone. Welcome to the Habitat Regulations Appraisal training session with NatureScot and Planning Skills.
My name is John Kerr. I work in our protected areas team in NatureScot and lead on the sort of casework and the legislative part of our protected areas work. So we've doing this introduction to Habitat Regulations Appraisal, HRA, as it's known. We will be doing a more technical session later in the summer, but this is very much a quick introduction to the whole process. Those of you who've had any experience of this before will realize that you can do a full day's training or more, but I'm going to try and distill all that down into maybe in just over an hour or so. So before we start, I thought it'd be useful just to get an outline of what we're going to cover. So first off, the Habitat Regulations Appraisal, the basics of it, where this applies, why, and in what circumstances do you need to do this. It's broken down into 3 tests, and we'll be covering those. And I'll touch on what's known as IROPI, Imperative Reasons of Overriding Public Interest, at the end, although that we'll do that in more detail in the next session. We haven't had many cases like that, so it's not something which is a major part of this process. So a quick overview of when and where. Many of you realize that this is something which is done in relation to what we now call European sites, used to be called Natura sites. So the first one that first designation just to cover is SPAs. These are originally designated under the Birds Directive, and they're listed. They're designated, classified as the term is used, to safeguard birds that are listed on the annex to the Birds Directive, and also migratory birds, and also their habitats. So this is a map just showing briefly the locations of all our SPAs in Scotland. As you'll see, there's some fairly large sites, including some marine sites, and also some fairly large sites in the centre of Scotland. There is 164 altogether across Scotland. Next slide, please. The next designation is SAC, Special Areas of Conservation. These are originally established, designated under the Habitats Directive, most of which were designated in 2005. The purpose of them is to protect habitats that are listed on Annex 1 of the directive, and species that are listed on Annex 2 of the directive. Now, this can be habitats such as blanket bog, can be there's woodland habitats, there's a lot of coastal habitats. The species concerned can either be animals, so seals and otters, for example, salmon, but also certain plant species as well, in particular various mosses and the likes. Next slide, please, Trevor. And this is just a map to show where they are. Again, there's marine sites. The one you might be able to spot that there's a few rivers as well, the Tweed, for example, and the Spey. There's a large marine site off the west coast, which is for harbour porpoise, and some other marine sites which straddle the offshore and inshore area, as well as a lot of sites, obviously, within the terrestrial environment. Next slide, please, Trevor. The third designation, which I'm going to talk about as well is Ramsar sites. Some of you may have encountered these. These are designated under the Ramsar Convention, which was dates from the 1970s. And this is a wetland designation, protecting wetland birds, habitats, and other species. Since last year, Scottish Government changed their policy on protection of Ramsar sites because there were gaps that had been identified by Environmental Standards Scotland. And now, since July last year, the government policy is that all Ramsar sites must be treated as though they are European sites for decisions on land use change. Now, most of these sites are already SPAs or SACs. So where there is a correlation between the boundaries and the features, then the HRA process that you go through for those particular designations will also double up as being a Ramsar appraisal. But there might be on some sites additional Ramsar features that are not covered by the SPA or SAC designation. And we've produced conservation objectives and information about that, which is on our website on SiteLink. But so for the rest of this session, where I'm talking about European sites, what I really mean is SACs, SPAs, and also Ramsar sites, which have got policy protection. There might be changes coming in legislation in the next year or so, following the Natural Environment Bill, which give Ramsar sites more statutory protection. But at the moment, that they are also covered by this. Next slide, please, Trevor. And this is just a map to show where Ramsar sites are. There's a lot of crossover, for example, in the peatlands in Caithness and Sutherland, and also elsewhere dotted throughout Scotland. They don't have a marine. There are no completely offshore Ramsar sites. Next slide, please, Trevor. So that's the where, and now we'll move on to the actual sort of nub of the Habitat Regs appraisal. And as you can probably imagine, it's called a Habitat Regulations Appraisal because it derives from the Habitat Regulations. The real name for those habitat regulations is the Conservation, Natural Habitats, etc. regulations. And these were UK regulations that were made before devolution. They still apply in Scotland and have been amended, I think, at least 25 times. So it can be an absolute nightmare to read. They were amended most recently when we left the EU, so that the network still applies, and all the rules and regulations around management and designation still apply. In England, they have more up-to-date regulations or more recent regulations. The Conservation of Species, Habitats and Species Regulations 2017. They apply in Scotland only for reserve matters, and that's principally for energy consenting, but one or two other reserve matters as well. They say pretty much the same thing. So, but again, for the purpose of this session, where I mean habitats regulations, principally it will be the 94 regulations. Next slide, please, Trevor. So the key regulation is Regulation 48, which sets up the whole Habitat Regulations Appraisal. What it says here, and I'll go through some of these terms later on, the terms that I've highlighted in blue here. But what it says is a competent authority, before deciding to undertake or giving any consent, permission, or other authorization for a plan or project, which is likely to have a significant effect on a European site in Great Britain or an offshore marine site, either alone or in combination with other plans or projects, and is not directly connected or necessary to the management of the site, shall make an appropriate assessment of the implications for the site in view of that site's conservation objectives. Now, one of the key things to point out at the start as well is that it's a competent authority before deciding to undertake or give any consent. So even if you don't need a consent for the work that is being proposed, it's still, if you're a competent authority, you still have to carry out an appraisal. And the final part of this is that in light of the conclusions of the assessment and subject to Regulation 49, which we won't cover, the authority shall agree to a plan or project only after having ascertained that it will not adversely affect the integrity of the European site. Next slide, please, Trevor. So the first bit there that was underlined is a competent authority. What is a competent authority? Well, it's a fairly broad term, but it basically covers pretty much every public body, including ministers, government departments, anyone holding a public office. This is all set out in the regulations. It also includes public or statutory undertaker. Now, statutory undertaker is defined according to the Nature Conservation Act, and that can include companies, organisations that are carrying out work with some sort of statutory license or underpinning. So that can include, for example, Network Rail. It can include energy companies because they have a license to carry out to install equipment. It can include telecoms companies because they also are operating under a license. So there's quite a wide range of bodies that are competent authorities. And going back to what I was saying before about competent authorities having to carry out an appraisal, even if they're planning to do something which doesn't need permission, that is where some of the obligations will fall onto some of these statutory undertakers. They need to carry out an appraisal of their own activities as well. Next slide, please, Trevor. So what constitutes a plan or project? Well, there's a broad definition of this. It's anything that can affect or have an impact on a European site. This was tested in a case of their Whitelink in 2010, which is a ferry company in the south of England got a new ferry which was larger than their older ferries, and they needed to dredge a channel further to which had an effect on a European site. And the court just determined that acquiring this new bigger ferry was a project in terms of the Habitat regs. So it's quite broad. Obviously, things like planning consent, licenses given by SEPA, consents that are given by NatureScot for SSI work will come under that because they can affect a European site. Felling licenses and other licenses given by Scottish Forestry, for example. It also includes plans and a whole wide range of plans. I've listed a few there, but I mean any sort of plan, whether it's a high-level plan covering strategy or something a bit more focused as well, is covered by this if it has an impact or an effect on a European site. Next slide, please, Trevor. So what information do you need to carry out an appraisal? Well, obviously, the location of the plan or project and information about European sites affected. And that most of that information, the qualifying interests, the map, the conservation objectives and the likes, you can find that on our website on SiteLink for every site. The other piece of information that you will need will probably come from whoever it is that's proposing or applying for consent or the developer as a sort of shorthand. And that will be information about what they're planning to do and what its impacts will be on European sites. And the Habitat regs oblige people to give competent authorities all the information that they need to carry out their appraisal. So if there's information that's missing, you're fully justified to go back to the proposer of the project or the plan and ask for more information. And this can mean that they have to carry out quite a lot of survey work for some of the larger schemes, or a lot more assessment of what that means for the implications on the European site. And that can, for some of the really big projects, take years of work. But it's down to the developer to fund that, and to carry out all that work. Next slide, please, Trevor. I'm mostly going to be covering the HRAs of projects. It's in some ways it's the easier one to do, but it also is more common. But where it comes to plans, it is fairly interchangeable. It's the same process that needs to be done. The big difference really with a plan is that you might not have all the information that is needed compared with, for example, a project. A project, you will know exactly what's happening, where something is going to go, the scale of it, timing of it, how it will be used, and all that sort of stuff, whether that's a housing development or a road or a piece of energy infrastructure or whatever. For plans, obviously, depending on what scale or what level of that plan is, it could be a high-level strategy, it could be at a slightly lower level, but generally speaking, the information that you gather for an SEA, for that strategy, for that plan, will also help to inform the HRA. And you should be able to have enough information to be able to screen things in or out. It's quite frequent that at different levels you have to do HRAs. At different plan levels, you do HRAs repeatedly as more information, more detail becomes available, and ultimately the final decision will be made at a project level for HRA. Next slide, please, Trevor. So from the Regulation 48, with all the information that's in there, it can be broken down into 3 tests. Some of you may have seen flowcharts before, which list, I think, up to 9 different steps in the process. It's not that there are 9 tests, it's just it sort of breaks down some of the process in a lot more sub-levels. But essentially, we often refer to 3 tests within the HRA process. And I'll go through these in turn. So next slide, please, Trevor. So the first test is the proposal directly connected or necessary with the management of the site? Next slide, please, Trevor. Now, I'm not going to go through this in a lot of detail. It mostly applies to the conservation management of the European sites in question. So it's generally speaking going to be relevant to people who are managing these sites, maybe as nature reserves. NatureScot manages quite a lot of land as a national nature reserve, and this test is quite relevant to that. It won't be something which is passed as a test for many developments. One of the reasons for that is that you have to be sure that the management that is being proposed, the work that is being proposed, whilst it might benefit, for example, one feature of a European site, you've got to make sure it doesn't then have an impact on others. And an example of this could be, for example, somebody that decides that they need to extract more deer from on a site to benefit the habitats on that site. And in order to do that, they want to put for example, a track across the protected habitat to enable vehicles to get in and out more quickly and everything. Now, obviously, controlling deer on a site might be very beneficial and might be necessary for the conservation management of that site, but putting a track across the protected habitat is not. that could have quite an impact. So the test wouldn't be met for that particular proposal. As I say, it's not a test that is regularly passed. So we normally then move straight on to the next test. Next slide, please, Trevor. Next test, which is likely significant effect. Next slide, please, Trevor. So this is the second of the two tests, or the three tests, sorry, that that we're talking about. Is it likely to have a significant effect? And we usually abbreviate that down to LSE, either alone or in combination. Next slide, please, Trevor. So this is a screening stage. It's often considered to be quite a quick and easy stage, but it is a screening stage. It's the idea is you are able to remove from further appraisal, further assessment, any of those plans or projects where there's no connectivity to the sites, to any European site or their qualifying interests, or if it's being done in a way that is really obvious that it won't have any impact or won't undermine the conservation objectives. So this is normally done by a competent authority. NatureScot is often consulted on this, and a lot of competent authorities, either through pre-app or as part of their assessment, quite often do come to us. We're trying to put as much standing advice as possible out to help people with this, so that we're not swamped with requests for this at this stage. Next slide, please, Trevor. So what this is about is looking at whether there's any connectivity between what is being proposed and the qualifying interests of a site. Now, that connectivity could be fairly obvious. It could involve if there's a loss of habitat, for example, or it might loss of breeding sites for protected bird species, for example. But there could also be other connectivity in terms of disturbance, in terms of how sites are used later on. For example, recreational increases in recreational use in the area. So there can be a whole range of connectivity pathways between the proposal that is being assessed and all the qualifying interests of a site. The term likely, I think, across Europe, it's been interpreted or been it's been covered slightly different. But what it really means is that there is a probable effect. It's not, yes, it's definitely going to be an effect. It's something which is probable and therefore needs to be looked at a bit more closely. And it also applies to impacts which are happening outside of the site as well. And you may see from people who've familiar with the process that some HRAs, they screen in or out or check a wide range of European sites that are often quite a long way from the site, from the development proposal site, and that's because there's no maximum buffer between the relevant proposal and the European site. We do get asked this quite often. Is what's the maximum distance I need to look at at this stage? There is no maximum. It's all about what the effects and the impacts could be on the European site and what it and those features. So some bird species and some mammal species can range, and particularly marine mammals, can have very wide range, can range from a large distance away from their, what you might describe as a home protected area, whether that's where they're nesting, for example, or their breeding sites. So particularly for wide-ranging species, there you need to think quite widely. Obviously, for other sites and features, there'll be a much smaller distance. But this also looks at downstream effects. So, for example, on rivers, what you might do at the head of top of a catchment could have an impact much further away downstream. Next slide, please, Trevor. So, a few scenarios here. This is just an example, Matt. We ignore the fact that this is an SPA, but this could be either an SPA or SAC. So the first scenario that we've got here, we've got a proposal which is within a European site, which could impact the qualifying interests within that site. Now that's quite an easy one often to determine that there's likely significant effect. There could be, for example, loss of habitat. There could be loss of breeding areas. There could be disturbance effects where qualifying species move away from that blue dot and stop using that part of the site. And there could be other impacts. There could be wider impacts from that. Light pollution, for example, if there's increased lighting for a proposal, there could be noise, there could be all sorts of other disturbance impacts there. Next slide, please, Trevor. So this is also going back to what I was saying before. Outside of a site, you need to consider if the proposal is not in a site, but you do need to consider nearby or relevant sites. Now this is this could be, for example, where there's a protected habitat, and there's downstream effects that could impact on that habitat from the development proposal. And just for the purpose of this slide, I mean that blue dot could be a lot further away. You'd still need to consider what the downstream effects are. There could be issues there where if it's a bird site, the site could be designated as a breeding area or a roost site, but the birds might be feeding outside of the protected area, and so therefore the development proposal could impact on their feeding areas, and that would also be considered to be a likely significant effect. Next slide, please, Trevor. So a proposal that is outside of a site and could impact qualifying interests that are also outside of the site, that could also be feeding areas as well. There could also be, for example, a barrier effect if they are flying from one part of where from a roost site, for example, to a feeding area elsewhere. And that could be they could be barrier effects. They could collision impacts as well, of which is something which is quite important or valid for wind farms, for example. So there's a wide range of connectivity pathways that you'd have to consider for impact on different types of European sites. Next slide, please, Trevor. So on likely significant effect, the test should consider proposals that are either alone, the proposal itself, or in combination and connect with other plans and projects. This is to avoid the death by 1,000 cuts of taking each proposal individually and then suddenly finding decades down the line that actually the protected area has been severely degraded because of these sort of cumulative combination impacts. What I would say though for cumulative impacts, we'll cover it a bit more later in the summer, but one of the key points with it is not to worry too much about it. If your proposal, if you consider that there is a likely significant effect just from the proposal itself, you don't need to then look at cumulative impacts. The purpose of this test is to decide whether or not a proposal needs to go through to the appropriate assessment stage. So if you've already concluded that there's a likely significant effect from your proposal in itself, it will then need to go through to an appropriate assessment stage. It doesn't matter what the cumulative, whether you have to, you don't need to then work out whether there are cumulative impacts that would trigger that that's likely significant effect. It's already been done. There is a different meaning between likely significant effect in the HRA process compared with EIA and SEA. And the key thing also here and throughout the whole appropriate assessment, whole Habitat Regs appraisal process is to apply the precautionary principle. So if you are not too sure about connectivity, then it's best just to take it through to an appropriate assessment stage. Trevor, next slide, please. A word about mitigation. There was a court case that was a European court case called People Over Wind about 10 years ago, and that confirmed that mitigation cannot be considered at the likely significant effect stage. It was an Irish case. It's been modified slightly more recently to confirm that what might be described as intrinsic mitigation can be considered at the likely significant effect stage. The logic of that is that if you exclude all mitigation, then you're considering a completely different project to what's being put forward. Intrinsic mitigation is anything that it would be standard to a project, no matter where it is. So, for example, a project that might impact on a watercourse, SEPA quite often require things like silt traps. That's everywhere. But any mitigation that is, and that can be included as part of the LSE test. Any mitigation, and the court confirmed this, any mitigation that has been specifically designed to avoid impacts on a European site cannot be considered at the LSE stage. There's various reasons for that. One is that mitigation that is specified in a project or put forward as part of the project, there's no way of guaranteeing that unless that is maybe put in as a planning condition or something like that. Mitigation, for example, somebody might say, well, we'll make sure that we will not do any construction work during sensitive periods for example, birds on a nearby SPA. And that might be fine, but timing can slip. So the advice that we always give is that mitigation that, as I say, that is designed specifically for the European site needs to be excluded from this and then can be considered more fully at the appropriate assessment stage. If you're in doubt, it's always best to screen these sites and features in to the next stage, which is an appropriate assessment stage. So we've talked about likelihood of an effect stage, and the final stage is appropriate assessment. And I appreciate that, and I just realised that during the question and answer session there, we tend to conflate appropriate assessment and HRA. HRA is the whole process. They're going through all the tests, and appropriate assessment, although that's the sort of the key part of the Regulation 48, the way it's written, the appropriate assessment is the final test, and so it is a part of the HRA process. I know that some people do get a little bit confused about what the difference is between HRA and appropriate assessment. Appropriate assessment is part of HRA process, the whole Habitat Regulations Appraisal. So next slide, please, Trevor. So just as a recap, the 3 tests, and this is the third of those 3 tests. And the question that's being asked is, can it be ascertained that the proposal will not adversely affect the integrity of the site? Next slide, please, Trevor. So this is the appropriate assessment. There are in effect 2 parts to an appropriate assessment. There's the appraisal itself, and then the conclusion that you come to. This is the responsibility of a competent authority to carry out, but the regulations say that the competent authority must consult NatureScot on an appropriate assessment and have regard to any representations that we make. Now, in reality, and I think Arabella will talk a bit more about the sort of, how things actually happen on the ground. What you might find is that we do what's known as a shadow HRA. You'll also find that a lot of developers will produce a shadow HRA. Most of them are told very clearly not that what they produce is not an HRA, not an appropriate assessment. It's information to inform an appropriate assessment, or words to that effect. But ultimately, this is the responsibility of the competent authority to do or to adopt an existing one, and then to consult us. Next slide, please, Trevor. So, what is appropriate? The legislation doesn't say how to do an appropriate assessment. It just says you must carry out an assessment, and it must be appropriate. So it really depends on the proposal and the possible impacts. We do appropriate assessments for SSI consent. As I said before, we generally use a performer for that, and that can just be a few sides, a few pages of A4. No doubt, many of those of you who've done or seen or been involved in quite a lot of Habitat Regulations Appraisal cases may have seen appropriate assessments which are hundreds of pages long. We always say that it just needs to be fit for purpose, and it doesn't need to be any longer than it needs to be, because we all have to read these, and it just needs to be to the point. It should be reasoned, and the everything should be recorded fully. There should be no gaps. That was part of an EU ECJ ruling. It basically said there should be no gaps in an appropriate assessment, and because it's an appropriate assessment in view of the site's conservation objectives, the conservation objectives are obviously central to this appraisal. Next slide, please, Trevor. So the conservation objectives, I'll just spend a bit of time just going through those. We've got them all available on SiteLink. For those of you who haven't seen SiteLink, it's a portal that we have on our website for all protected areas. it's also actually the official register of European sites for Scotland. So on there we have a lot of information and site documents for European sites, including maps and including conservation objectives. Now, at the moment, the conservation objectives are in a slightly different format for SACs and SPAs, but I'll just we've got a few slides just to show you what that looks like. So, next slide, please, Trevor. So, SPAs all have, or most of them have fairly generic conservation objectives. So the key things in there obviously are to do with the population of the species as a viable component of the site. There's also objectives about the distribution of the species throughout the site and their habitats, and also an objective about disturbance of the species. Next slide, please, Trevor. For our SACs, we've produced what we call conservation advice packages, which include conservation objectives, but also a bit more information about the SACs and some information about conservation measures that would benefit those sites. And they're all on SiteLink as well. Next slide, please, Trevor. The conservation objectives are made up of in two parts, really. There's the high-level objectives, which are basically for SAC features to make the greatest contribution towards favourable conservation status, which is a legal requirement, a legal obligation set out in the Habitat Regs as the management objectives for these sites. Next slide, please, Trevor. And that's broken down into three separate objectives covering extent and distribution of habitat, structure and function, and the distribution of typical species. For species sites, then there'll be obviously an objective about population instead of extent and distribution of the habitat. But these are linked to the definition of favourable conservation status. Next slide, please, Trevor. For our marine sites, we have documents called Conservation and Management Advice. They're much the same as our conservation advice packages, but they have a slightly different legislative purpose. There's a slight difference between what we have produced for marine sites compared with terrestrial sites, which is set out in Regulation 33 of the Habitat Regs. But if you see something called a conservation management advice document, that's where you'll find conservation objectives for the marine sites. Next slide, please, Trevor. I should also say that we've produced these conservation and management advice documents for some marine SPAs as well. So we also produce within that a bit more information, what we call supplementary advice, just to help inform what the conservation objectives actually mean. So hopefully that will make the appraisals a lot easier. So for an appropriate assessment, it's all to do with whether there's an adverse effect on the integrity of the site, and that's what you're trying to assess. Now, this is linked to whether or not the conservation objectives will be undermined, and so you would need to go through each site, each site if you're doing multiple, but each of the qualifying interests of those European sites. The easiest way to do that is logically apply each of the conservation objectives for each of the relevant features. Now, if you've screened out any features at the likely significant effect stage, you don't need to cover those in this appraisal. That's the point of the LSE stage. If there's no likely significant effect, you don't need to do an appropriate assessment. But most of the appropriate assessments that you'll see, people will go through each of the conservation objectives and apply them to those each of the features. And obviously, if there's similar features, you can brigade them together. So, for example, for if you're looking at an SPA with lots of different wading birds, and they've all got similar ecological requirements, then you can brigade them all together. But it's whatever makes sense for that particular appraisal. At this stage, you can consider mitigation that is needed to avoid an adverse effect on site integrity. Next slide, please, Trevor. So a bit of information about mitigation, advice on mitigation. Environmental Standards Scotland did an investigation a few years ago to look at mitigation and how it is applied to habitat regs appraisals. And they reiterated really a lot of the guidance that's come out from Europe about mitigation. And the key things about mitigation is you need to know whether it will work. And also, can those mitigations be secured? You know, often mitigation can be secured through planning conditions or other conditions to a consent or license. Will it work is a key one. There can be, and you see in some old consents, rather sort of vague mitigation. For example, on we've seen one down south in England where for housing development that was close to an SPA for birds, they thought the mitigation would be just to ban all residents from having cats or dogs. Now that obviously would have an impact. It would benefit the nearby bird features, but it's almost impossible to actually police. So will it work? Probably not. There's also, particularly where there's adaptive management needed, you need to be able to monitor the mitigation and make sure that it's working, and therefore be able to amend it if necessary. The other thing also to be sure of, and it might seem obvious when you say it, that you can't have mitigation that then impacts on other qualifying features of a European site. The idea of this appraisal is to make sure that there's no adverse effects on the European site, even with the mitigation in place. So next slide, please, Trevor. So as a conclusion for the appropriate assessment stage, the question that is being asked is you've got to prove the negative. It's will the proposal not, it cannot be ascertained that the proposal will not adversely affect the integrity of the site. So this is really application of the precautionary principle to the legislation. It needs to be shown that is beyond all reasonable scientific doubt that there is no adverse effect on the integrity of the site. And it also means that there's no threshold of what is acceptable loss. And that can mean that quite small or very small losses of, for example, habitat or breeding sites or whatever have been considered to have an adverse effect on the integrity of the site. This is all determined on a case-by-case basis. There's no sort of set limit or formula for saying, well, this is acceptable loss, this is not acceptable loss. Next slide, please, Trevor. So the next stage, and I'm only going to touch on this briefly, is what we call the Europe derogation. Next slide, please, Trevor. So you worked through all the three tests, and you've concluded that it's not necessary for the conservation management of the site. It is likely to have a significant effect on one or more European sites. And it cannot be ascertained that the proposal will not adversely affect the integrity of the site. It's quite complicated wording that, but you can't therefore conclude that there's no adverse effect on the integrity of the site. Next slide, please, Trevor. So what then? Next question. Next slide, please, Trevor. There's a derogation which is set out in the regulations and also in the original Habitats Directive. We routinely refer to it as a ROPI. It's one of the many acronyms within this process. It stands for Imperative Reasons of Overriding Public Interest. And this means that proposals can be permitted only where if there is an adverse effect on site integrity. It can only be permitted where there are no alternative solutions, where there is this imperative reason of overriding public interest, and where compensatory measures are taken to ensure that the overall coherence of the network is protected. We don't have many cases like this in Scotland, which is why I'm not going to spend an awful lot of time on this today, but we will next time. In Scotland, until quite recently, there was probably 2 cases that we can think of, building the road out to Mallig through Glen Beesdale, and some work that was done on the West Coast Main Line just south of Glasgow. There's more of this coming in now through a lot of the energy cases, particularly offshore wind, but also some of the onshore transmission lines. We're encountering this more, and 1 or 2 other schemes for generating electricity, pump storage, for example. But it's not something which we've spent an awful lot of time on up to now dealing with. Next slide, please. But it is a good opportunity for me to clarify the difference between mitigation and compensation. As I said before, mitigation can be taken into account and should be taken into account at the appropriate assessment stage, and that can inform maybe some of the conditions that are attached to a consent or a permit. Compensation cannot be taken into account until you get to this derogation stage, and as I say, therefore, it's not something which is taken into account very often in cases in Scotland. But things like the mitigation hierarchy, which includes both mitigation and also measures like offsetting and restoration and remediation, compensation, phrases like that, depending on which version you look at, can maybe confuse people. So the difference here, mitigation is really very intrinsically connected to the project itself. It might be to do with the design of the scheme or the development. It might have something to do with the timing of the construction. It might have something to do with reducing the impacts of that development on a protected area. So usually cannot be put into place without the development actually being there. Compensation is usually to offset or compensate, replace the losses that have been seen through that development. A lot of the sort of compensation measures that are proposed, recreation habitat somewhere else, or some sort of planning, some sort of measure to improve habitat on the site. That could be done in any case. It's not connected to the plan or project. And that can only be taken into account at this final stage. It cannot be taken into account in an appropriate assessment. So a developer might come along and say that as part of their development, they will also, to offset some of the losses or the impacts or the harm, they might fund a scheme to improve habitat elsewhere, or they might do something to try and encourage greater breeding success of protected birds, so something like predator control or something like that. That's compensation and has to be ignored through the HRA process unless it gets to this stage with a ROPE. Okay, next slide, please, Trevor. And that's the end of the process. I've put up a slide here about some key sources. I've referred to SiteLink a few times, and that is really a key source of information. We do also have guidance on our website. And the other one that we refer to quite a lot in NatureScot, certainly in my team, is the European Commission's guidance on managing Natura sites.
And thanks, John, for that presentation. So yeah, just to introduce myself, I'm an operations officer and I'm based with NatureScot. I'm working out of the Kirkwood office up in Orkney. So I was asked to come along today just to provide, I guess, a walkthrough of what our role is as case officers at NatureScot, and you know, how we engage with local planning authorities and also with the Habitat Regulations. So I'm kind of hoping that this short presentation just provides you with, I suppose, a better understanding of how NatureScot handles casework, basically when a planning consultation which might impact a European site lands on our desk. And yeah, based on, I suppose, my own experiences of a case officer, I've added some suggestions throughout and at the end of the presentation, just I suppose from my point of view, what I feel is, you know, some top tips, good practices that might be helpful when handling protected areas casework just in general. But I think this is also a good opportunity as well for us to learn from any planners out there who've got any suggestions or ideas of their own and how to kind of improve the kind of working arrangement that we have. So welcome those at the end, or I guess if we've run out of time, we can kind of pick them up in the comments and so on. So yeah, next slide, please, Trevor. Thank you. So as some of you may be aware, if you've engaged with NatureScot or with any operations officers, we're quite involved as operations officer in quite a diverse range of different tasks, but our primary work really revolves around delivering NatureScot's statutory role in planning casework as case officers. And this includes the provision of advice to local authorities along with other regulators, developers, partners that we work with. So I'll try not to cover too much ground that John's already covered, but there might be a wee bit of repetition here just for some context. But so when, as John kind of covered, when European sites could be impacted by a planning application and an HRA needs to be completed by the competent authority, it's likely that NatureScot will be consulted and involved in either some, if not all, of the process. And in these contexts, so case officers like myself, we would be the main point of contact between NatureScot and the local planning authority. However, it's just to kind of make you aware that, you know, depending on the complexity or the type of proposal that's come through, it's likely that the response that you receive is a kind of collaborative response that has kind of brought in different internal advisors, area managers, even directors in some circumstances as well. So again, it kind of depends on the complexity of the case and the level of authority needed to sign off a response. So it's just to say you'll kind of have one main point of contact, but there's a kind of team behind that response that has been involved in pulling that response together. I think at the outset as well, I was quite keen just to, I suppose, set some caveats to what I will present today, and in that, you know, assessments and applications that we receive, we assess them case by case, and I think, you know, what John touched on as well, it's not really possible to set, I suppose, thresholds or to standardize the assessment in any way. You know, there's no one size that fits all. So you know, as I go through today, you know, and as John's covered off, it's quite hard to set, you know, limits or thresholds on this. So you know, it's quite varied in its nature. But I hope, you know, kind of be offering my own perspective and experience of handling casework today. And, you know, I'm also aware that we work across Scotland and there'll be differences between how local planning authorities handle casework. And similarly, from my experience, there may be differences between NatureScot area officers and area offices. So yeah, it's just to kind of suggests that the best way forward really is to maintain good contact with your local office or directly with a case officer dealing with specific casework, just to kind of make sure that everyone understands the role and at which part we may come in to provide advice on. But I suppose the bottom line is that it's important that we get across today that our advice from NatureScot, we aim to be consistent, evidence-based and proportionate in how we handle casework. So hopefully that, you know, is the kind of common picture across Scotland. So next slide, please, Trevor. Thank you. So yeah, again, just covering briefly some ground that John covered here today in terms of NatureScot's role in an HRA and how and when we would kind of get involved in the HRA process. So as John covered, any plan or project that could affect a European site should be subject to an HRA. And as described today, a competent authority is the authority with powers or duty to determine whether or not a proposal can proceed under the Habitat Regulations. So in the context or in relation to planning applications, the competent authority would be the local planning authority. So what we would kind of expect the process here to be is that the competent authority, they'll review a plan or project for likely significant effects on the European site, and NatureScot can be consulted at this stage and provide help with this if required. However, the decision on likely significant effect is made by the competent authority, and it's not a requirement at this stage to consult with us, but you know that may be an option that you choose to kind of consult with us at that stage, which is fine. However, where it has been concluded that an appropriate assessment is required, the competent authority must consult with NatureScot. So that would be at stages 4 and 5 of the HRA, which I think John covered off. So that's typically the point at which we would expect to see consultation from a local planning authority on any plans or projects. Again, John covered kind of stages 6 to 9, and as you mentioned, these are only really considered in exceptional circumstances. But again, if these stages are reached, then these stages would also require consultation from NatureScot, and also would expect Scottish ministers to get involved in that stage. But that's complex stuff, and I'll leave that to John. I think he may cover that in future sessions as well. So I'll move on to the next slide, please, Trevor, if that's okay. Thank you. So it seems as though there's a kind of mix of experiences of those here today on how you've engaged so far with the process and with NatureScot and the consultation process. But so some of this might be quite familiar to you, but I thought I would just kind of outline what the process is on how you actually consult with NatureScot and what are the steps involved. So Informed Decision was launched in February 2025, and this is a new way of providing our statutory advice to the likes of local planning authorities and other partners who we work with. So NatureScot designed Informed Decision to help applicants understand whether or not they are required to consult with us, and essentially it's a way to ensure that our advice is provided efficiently and consistently across the organisation. So the process of using Informed Decision from a local planning authority point of view is that any requests seeking our advice for statutory or even pre-application advice should be submitted via Informed Decision. So I've added a link there on the screen, but I'm sure this is something that you may be familiar with already. So once you kind of go onto the platform, onto the web platform, you'll go through a series of initial questions, and depending on the reason why you're consulting with us, the development type and the location of the proposal, you will either be filtered out and told you don't need to consult any further with NatureScot, or you'll be filtered into system. Just to kind of avoid any doubt, if the proposed development takes place on a protected area, such as a European site, or importantly within a buffer around that development site, then your application will automatically be filtered in. There's also other application types such as EIA, which will also automatically be filtered in, but I won't go into too much detail on that today. So if the circumstance is that you are filtered in, you'll be then prompted to go on to the next stage on Informed Decision, where you'll be asked to provide some more detail on the proposal or the application. And I suppose this is the stage at which you're able to kind of elaborate or provide more details on the proposed development. And there's various ways that you can do that, but any specific requests that might come up or that you want to focus our attention on or focus our advice on, you can there's a kind of notes section where you can add in that detail. I'll kind of cover a bit more of this later on, what sort of things you might want to include there, just to help, I suppose, focus our advice or to streamline things a bit. At this stage, there's also an option to upload attachments or additional documents. So it's just to note, as local planning authorities, you only need to upload additional information that's not already within the public domain. So I think the best example of this would be information that contains sensitive information that might be relevant to the request to us. So typically this would be something like an ornithology survey result, which may contain like location of breeding bird species. So that's the only sort of additional information you may need to attach to informed decision requests. All other documents that are already available in the public domain relating to the case, the NatureScot case officer will be able to access them through the planning portal and will be able to kind of upload them to the case itself. So you don't need to worry about kind of adding in multiple documents to your request. Also within this stage of informed decision, you would submit the date when you would require a response from NatureScot by. So we tend to use our statutory response timescales unless there is a good reason to respond sooner. But again, there may be, I suppose, option to discuss or to negotiate deadlines with the case officer once the case has been assigned. I'll kind of cover a bit more of that later on about timescales. But yeah, it's just to note that at the application stage and informed decision, you can change the date to a date that you require a response by. And yeah, that's the kind of application stage at informed decision. And so then once all that information has been submitted and the case has been filtered into the system, what happens next? It gets triaged. So applications that are filtered in, these will be triaged by NatureScot staff. So this is the stage at which a case will be, we'll review the case and make sure all the right information is filed in the right place. And the case itself will be assigned to a case officer. And how the cases are assigned, it's based on a number of different factors, but usually it's kind of a combination of the geographical location of the proposal and the case officer themselves. If the case officer has had any previous involvement with that particular case, or also the case officer themselves, if they've got any experience or kind of speciality on the topic or the type of development that's come in. And also ultimately it comes down to case officer capacity. So who within the team has got capacity to take on cases. And it may be that cases that would typically land on a particular desk of a particular case officer, due to capacity, may have to get assigned out with that area. So, you know, you may often find you get responses from a number of different case officers, and that's usually the reason why. So as I've mentioned at the start, the case officer that the case is assigned to, they're the lead person responsible for that case and will be your main point of contact. And they'll have the kind of allotted time scale to respond to the consultation. The next stage, we would move on to kind of reviewing all the documents. So as a case officer, we'll review case documents. That would include the general application information, proposal details, but also any supplementary information, like I mentioned, ecological survey results and appraisals that are provided by the applicant. So as John mentioned, you know, if the casework impacts European site features, and it's a particularly large or complex development, we would expect to receive either a shadow HRA or sufficient information to inform an HRA from the applicant. So information to inform the HRA will vary, and that will depend on protected areas impacted and the qualified features of the site, but also on the kind of nature and the scale and type of development being proposed. So again, it's very hard to be too prescriptive about what we would expect to see. But, you know, typical examples would be things like habitat survey results or ornithology survey results, as well as an interpretation or an assessment of any survey or data collected by the applicant. what we would, I suppose, deem sufficient for one type of development may not be the same for another type of development, and the requirements really need to be assessed kind of case by case. So I think what we would really advise in circumstances, particularly where the development is particularly complex or maybe more contentious or even affecting multiple sites and qualifying features, we would advise applicants to approach us before the application stage and gain some kind of pre-application advice on information and data requirements, just to ensure that when they get to the application stage, all the information that is needed to inform that HRA is kind of provided at that stage, and it avoids us having to kind of go back to ask for additional information. For developments which are less complex, we have very good standing advice on our website, which we would encourage, well, we would encourage all applicants to make use of. So that kind of sets out details on survey requirements and also you know, how to carry out environmental appraisals and HRAs as well. So there is a lot of good resources on our website to make use of. At this point, we may also bring in specialist advice from our internal advisory teams. So we've got specialist teams who can offer advice on various different environmental topics, habitats, species, specific teams, for example. So depending on the complexity of the case, we may kind of combine advice from different advisory teams, and the response that we provide at the end will be a collation of all advice from all relevant specialist teams. So basically then it leads on to the response. So we would provide a response which is detailed to, I suppose, we would the detail provided will be proportionate to the scale and nature of the development proposed, as well as, you know, the potential impacts on protected areas. So we will typically use quite standardized wording depending on which response type is being applied in that circumstance. Where shadow HRA has been provided by the applicant, we may also provide comment on that where we agree with it, where we disagree with it, and outline our kind of reasoning and rationale behind why we've responded in a certain way. Just to kind of briefly mention timescales again, we aim to work within the applicant and the timeframe set by those consulting us, and issue our response within that. But for particularly complex cases and where there are multiple protected areas concerned, which subsequently involves a number of kind of specialist advisory teams to get involved as well, we may require additional time, and, you know, we would submit requests for extensions to the planning officer as soon as possible, just to ensure that we can kind of flag any concerns and any additional time requirements that we need at that point. Could I go on to the next slide, please? Thank you. So we've got just running out of time, so I'll briefly say that we've got kind of 5 positions which we would adopt when we're responding to planning applications. We've got no comment, advice only, which we would use in a number of different scenarios where we advise that there will either be no LSE or LSE but no adverse effect on site integrity. And, you know, these response types are usually quite focused and targeted at the key issues at hand. Holding objection, so in the context of European sites, we would use this response where we have concluded that there is insufficient information to determine impacts of the proposal. Conditioned objection, which we would use in context where the effect on site integrity can be avoided by specific changes or mitigation. Or we can agree that the mitigation proposed by an applicant is sufficient, and we would be advising that that is implemented as a condition, basically. And finally, outright objection. And this is used in very few scenarios, but it's essentially where we have concluded that there will be a likely significant effect, and adverse effect on site integrity cannot be avoided or mitigated. So you'll basically receive one of these 5 position type responses, and where, you know, we'll set out a response that we're very clear on which of these 5 response types we're using, and if there's any need for further information, we'll try and set these out very clearly at the start of a letter so that they're quite obvious. And similarly for conditioned objections, those recommended conditions will be set out clearly at the start of our letter. So I'll move on to the last slide. Just briefly mention a couple of top tips, I suppose, are good practices that I have found quite helpful in the process when I've been handling casework. So very briefly, probably most of it's quite straightforward and obvious, but clear and focused requests for advice. So I think it really helps if we understand exactly why we have been consulted. So sometimes that's quite obvious, and it might just be that we're getting consulted on the appropriate assessment stage of an HRA, and that's fine. But if the competent authority is looking for specific advice on different aspects of the HRA, whether it's the screening stage for LSE or at the appropriate assessment stage, or even on mitigation measures, it's very helpful for us to know that so we can focus our advice. And I'd recommend, that information could be provided either at the informed decision stage, or once the case has been assigned to a case officer, that discussion could happen between case officer and the planning case officer. Sufficient data and information. So in order to carry out an HRA, the competent authority must have sufficient information about all aspects of the proposal itself. So this might be the details of the proposal, methodology, timescales. And I think I've learned, don't assume that the information provided by the applicant is sufficient to assess the impacts. I think when completing the HRA, it's important to be very clear what information has been provided by the applicant, but then also what kind of inferences or interpretations have been made on top of that. And then finally, if any more detail is needed, that should be quite clearly flagged. And that's something that we would also kind of review and screen for when we're reviewing documents. Again, I've mentioned standing advice already, so we've got quite useful resources on our website that I'd recommend using. We've found, certain requests for our advice could be handled more directly by just referring straight to our standing advice. So really encourage using these resources as a first stop before, seeking any more specialised or bespoke advice from NatureScot. I think is recommended. Again, timescales is just to mention that, we've got NatureScot have published our own timescales for responding to different consultation types online, and this is what we would use in most circumstances. However, we do occasionally receive requests to respond sooner, and that may be for various different reasons, but unless we know why or have a good reason or justification on why a shorter time period is needed, it's sometimes quite difficult to meet that. So again, I would just advise case officers to speak to each other and to communicate why a shorter timescale might be needed, and that would help us to understand what to prioritise, and if it's reasonable to respond sooner, then we can see what can be managed to make that work. But vice versa as well, there's often times, like I mentioned, when NatureScot staff require a bit of extra time due to complexity of cases or capacity of the casework team themselves. So it may be that we come to planning authority or the case officer just to seek additional time. And again, it'd be good just to have, well, we would normally request that formally via email, but often we might just pick up the phone as well to discuss that first, to understand what is reasonable. Just to mention post-application interactions, we often will continue to engage with the local planning authority after an application has come in, and it's just to flag that these are not handled on an informed decision. These inquiries should be made directly to the case officer who handled the case, or if that isn't known, directly to the area officer. Best practices with these is just to make sure you use the reference codes that you had for informed decision for the case, and that will help us to kind of dig out any case history quite quickly. And I think finally as well, again, just to reiterate, making contact with the local office or with case officers at NatureScot. I think from my experience, I've gained a lot of understanding from discussing cases and picking up the phone to the local planning authority just to understand their processes better. It's also helped me to understand how to present and frame my advice or NatureScot's advice to on planning consultations, just to ensure that the key messages that we want to get across are I suppose obvious to the planning authority, and that we can make sure that everyone's on the same page about what we're asking for or what our advice is. I will probably stop there, I think, because I know we've run out of time.